Let me know when you.
Well, okay, we're recording, and let me do Facebook Live. Thanks everyone for joining. It's gonna start soon. Going. All right, let's see. Group.
Live stream. Cool.
Got it. All right, I think we're on Facebook Live.
I got a note.
Oh, you got
telling
a
me that you're
note.
being live streamed.
Oh,
so
great.
I think it's happening.
Oh, it's happening. All right. Well, thank you. We're gonna be learning how to figure out how to even do family will, trust, estate planning. It ain't sexy, but
Hey, speak for you.
but I think this is so important for us as parents to figure out how to start, what to do, how we're gonna do it. And it's like one of those things no one tells you to do or when you're supposed to do it or how to do it. You just kind of have to figure out. And I don't even know if you would like, you ask your friends about it. It's not like it's not something you like can ask them. Maybe I guess you can ask your parents about how to do this, but I don't know. I'm so grateful we have you, Jen, to figure it out.
Yeah. Well, thank you for the invitation. It's lovely to be here. And this is a topic that I actually really love to talk about. I love to demystify some of these things that are that can be complicated or feel intimidating, because ultimately these are often things that are wise for the vast majority of families to put into place. Really for any adult any person over 18, there are certain pieces of this that are wise, but then especially once you have kiddos in the mix, there are certain things that you can really only accomplish in a will, and that you can accomplish most easily in a trust, depending on your goals. And so we're just going to do like a quick little intro to those things, and then I'm happy to answer questions. Let me see if it advances. Oh, it does. Yay. Okay. So my name's Jen. Hello. I am a lawyer mom. And like I said, I love helping families think through the process of how to protect their loved ones and their legacies using these, some people think unsexy tools. I'll leave it up to you at the end what you think. And so I'm in Maryland. And so I do actual planning for clients in Maryland. And I also do some values-based coaching for families everywhere, because I know one of the things that can be really intimidating about this process is the idea of just like going in and meeting with a lawyer and not feeling prepared. And so the coaching I do for folks helps folks to really clarify their values and maybe feel a little bit more prepared when they go in for that meeting with their local attorney. So one of the reasons I enjoy talking about this stuff is because I think there's a lot underneath it that is interesting. There's a lot of things that you can learn about people and what they value, what is most important to them, the things that they want to pass on to the next generation, not just like their stuff, but also their relationships and their stories, and these like kind of big picture, like meaning of life things. And so I'm trained as a pastor, so it's maybe not surprising that I find that stuff interesting. And so I love it. So we're going to dive in. These are my munchkins. My daughter Lucia is 6. My son Simon is 2.5. They are hilarious beings, and I love them. And I'm also glad that they're doing their own thing right now. I love them best when they someone else loves them during the day, and then I can love them other times.
Totally. So our values, just really quick. So values and like your personal stuff, it seems like kind of also blends into when you're doing your wills and trusts and all that legal stuff. Like it
absolutely
connected together.
So I think so. I think that in order for a plan to be really comprehensive, and to accomplish the kinds of things that you want it to, you really need to think about the goals that you have at the outset. for example, and we'll get to this in a little bit, but one of the things that's super important for parents of young children is to figure out who they would want to raise their kids if they're not here to do it themselves. And that's like a hard conversation. And some people may have be in the lucky position of just sort of like having a large bunch of people to choose from. Other people may not, right? Like families are complicated, relationships are complicated. Maybe kids have special needs or other things that might make it kind of harder to think about who would be able to provide the kind of life you would want for them. And so often in those more challenging conversations, I find it really helpful to like take a step back and really reflect on your own values and your goals. And then once you're really clear about that, it becomes easier to sort of rank the choices that exist and figure out maybe ways of ways to make it easier for the people that you want to say yes to be able to say yes. And so, but I really do find that like downshifting into that like values space can be really helpful in those hard moments.
Very cool.
Yeah. So please jump in with more questions. I love the chatting. And I think we'll open up it up for questions at the end, is my understanding. So so just a little brief overview. We're going to talk a little bit about what wills and trusts do. We're going to talk about some of the things that might seem as like the extra documents, but that are also super important and part of creating, as I said, this like really comprehensive plan. And then I'll tell you about some things that you can do right now to like help organize and feel prepared so that when the time is right for you to do this work, you will be able to like do it. As I mentioned, I am an attorney in Maryland. I am not in California. There's a lot about these things, this like general framework that is the same everywhere, but nothing in this presentation is designed to be legal advice. I don't know you or your families, and so would not be qualified to give legal advice in this setting. So standard disclaimer, this is information that I hope is helpful and can lead you down a useful path, but not advice. Here we go. Wills and trusts, what they do. You've probably heard of these things. At the very least, you've like seen movies where they're like dramatic reading of the wills right after someone dies. Like in what is that one? Knives Out. That's a good recent example. That doesn't actually really how it happens, but it makes for good TV. And so a will, people have heard of. It is a place where you would name who would take care of administering your estate after you die. So your estate is just like your stuff, all the things you own, everything from like your cookbooks to like your house, to like your bank accounts, investment accounts, retirements, the like, you know, broken car in the garage in the back of your house, right? Like everything that you have. So there are the person who is in charge of that is a person that you would name in your will. So that's one of the important decisions to make that can really only be named there. So also in a will, you leave instructions. So you decide what happens to much of what you own. There are some things that you might own jointly. So say, for example, if you own a house and you are married, maybe you own your house jointly with your spouse. That kind of ownership is not dealt with in a will, as long as both of you, you know, if there's a survivor. So if you die, but your spouse survives, then your spouse just assumes the full ownership of that property. So it's not something that a will needs to handle. However, if you own your house just in your name alone and you die, then that's something that a will would take care of. And so if there are different ways that people have jointly owned property. And so that's, you know, we don't want to get too far in the weeds, but that does impact what property is under the purview of a will. One of the big things that you can do in a will is name guardians for minor children. So we talked a little bit about that earlier. In most states, a will is the only place where you can do this. And so even if you are not sure what you want to happen with your other stuff, even if there are other parts of these decisions that you want to like put off until later, I really advise people to consider putting a will in place, if only to name those guardians for minor children. The way that you I also recommend people have a deep bench. If you have a deep bench in your life, make use of that, and create first choice, second choice, third choice, kind of as many choices down the list as you would like. That serves a lot of purposes. One being that even though it's wise to revisit these things every couple of years, life happens and people don't always revisit it every couple of years. And so if this needs to come into effect 10 years from now, maybe the people you listed in the first choice are your parents, and maybe they're like 80 now, and maybe that's like maybe not the best fit anymore. And so it's helpful to give everyone involved kind of a list, because then it makes it easier for them to say no if things have changed and it's really not going to be good for everyone. And it also gives you the opportunity to like share that information with the people who are on the list, so that they know that they may be someday asked to serve in that role. So wills also must go through the probate process. So I would ask for a show of hands, but not everyone has their videos on. But some people may have experienced the probate process, maybe through the passing of relatives. But it is that court supervised process that happens after someone dies. You take the person that you name as your personal representative, takes the document to the judge and says, hello, I have a will, like, let's do the steps. Okay, we will do the steps. It will take a long time and it might be expensive, but like, here we go. So a will must go through that process. And that's kind of the way that the court makes sure that everything is happening according to your wishes. The other kind of key point that sometimes is confusing to people is that a will is only effective after you die. It doesn't have, nothing in your will has any impact on anything at all while you are alive. And so sometimes that can be confusing for folks, but it's so just helpful to clarify.
What if you're in like an accident or something like that, and you're in like the hospital? Like, does that your will kick into who's going to watch your kids then, or it's only literally?
Oh, that's in those extras that are important that we shouldn't skip. So if you are alive, even if you are incapacitated or experiencing disability, or you can't make your own decisions or care for your kids, that is where a series of other documents, often kind of under the categories of powers of attorney, will come in handy. So we'll talk about that in a second. So I know that most, if not all, folks here are in California. And so states handle the probate process differently, right? So in Maryland, probate isn't like the worst thing in the world. It takes a little while. There are some fees, but they're not crazy. But in California, the probate system across the state is like pretty backed up and can take like years, and can be very expensive. And so a lot of people that I know who practice in California, often the clients who come to them are interested in avoiding probate to the extent possible, because they don't want their family and their stuff to be like tied up in this process for a really long time. And so that's one of the advantages of a trust, because a trust does, the property that is put into a trust does avoid probate. So I like to think about a trust like a bucket, like one of those like sandcastle buckets, and with a handle. And so you create the trust, and the person who makes the trust like tapes a list of instructions on the front of the bucket. And then oftentimes the person who creates the trust also is the trustee. So they are the person in charge of holding onto the bucket and like managing everything, and still using the property that is in the bucket. And they can use it for themselves, they can use it for their families, they can use it kind of however they want to while they're still alive. Once they die, the instructions on the bucket tells you like who the bucket passes to, right? And so you list a new trustee, or maybe a series of people who could be trustees after you die. And so that is why that property doesn't have to go through probate, because it never actually doesn't, there's never no one responsible for it, right? So in a trust, the trustee is always responsible down the line. They pass the bucket like a little brigade, and they are responsible for managing that property. Often, parents of young children would name their children as beneficiaries of the trust for after they die. So a beneficiary just is a long fancy word that just means they are receiving the benefits of that property. And so the trustee has a legal obligation to manage the property in a way that is in the best interest of the beneficiary. So, so in the instructions that the creator of the trust would make, that the take to the bucket, right? It sort of lays all of this out. And so you are able to provide for many different kind of possible scenarios, and help the people in your life understand what you would want to happen in those kinds of scenarios. Another thing that people with young children find really appealing about trusts is that it allows you to safeguard the inheritance for your kids, safeguard them, that those assets from your kids' own immaturity, right? Like in most states, children have access to their full inheritance at 18 if it is passed to them through a will. And so, you know, if you think about life insurance, retirement accounts, any assets, right? It could be $500,000, right? Like even those of us who don't have a lot in our bank account now, we might have a life insurance policy that would be cashed in if we died. And then, you know, whatever wasn't used to get your kid to 18 would be available to them to blow on like one hot weekend in Vegas, or, you know, their education, right? Like, and so a trust allows you to safeguard those dollars for a lot longer, and to put in place kind of trigger points for when maybe the child has demonstrated enough responsibility to be able to receive larger distributions from the trust, or even take over management themselves. So that's another thing that can be super helpful. About trusts, I cannot see my own slides. I'm going to move you all. I hope that doesn't do a weird thing for the feed. Many layers of protection, yes. Okay, no, those are all the things. So another like just little side thing, I talked about trust as a bucket. You can make a trust during your lifetime, or you can set up, like write the instruction sheet and attach it to a will, so that the bucket sort of springs into existence through your will. That's another way that you can do it. Again, less popular in states where people don't want to use a will as their primary vehicle, because they want to avoid the probate process. People who do use trusts, though, still need like a little mini will, because they need to name those guardians, right? So the guardians can still only happen in a will. But if you have a trust as your like main vehicle for planning, your will would just be like a little baby one, mostly for that purpose.
And we're going to give everyone after this who's joined like some tips and tricks to kind of like the cheat code for all of this too. So you guys have some ideas of what you can do too. So I know I'm taking some notes, but other people, just so you know, you will get something afterwards.
Yeah. So great. So then this slide is just about some of those extras. And so Brooke asked a great question earlier about like, well, what if you're in the hospital and you can't take care of your kid? That is a great question and really important to plan for, because you never know. The world is unpredictable and crazy. And so to that end, there are these list of documents can be really helpful. One is a healthcare advance directive. That's where you name people or one person to make healthcare decisions for you if you're not able to make them yourself. And so that is a really important thing to have in place, because again, most people don't plan to not be able to make decisions for themselves someday. And so putting that in place is a great way to help your family kind of know what to do if this were ever to happen. Not necessarily know with certainty, right? But just like give them more guidance than they would have otherwise. There's also a financial power of attorney. That is a document that gives someone the authority to make decisions over your financial life. So they can like get into your bank account to pay your mortgage. They can manage your house. They can like handle your car, right? They can manage your financial life. They can be in charge of distributing money to the people who are taking care of your kids, right? So they have a lot of important jobs. And then in different states will have different terminology for this, but naming an emergency short-term guardian for children is also important, because remember, those guardians that we named in the will, No one cares about that if you're still alive. And so these emergency short-term guardianship designations, there's so many words, are important and are a way to make sure that someone who is, preferably someone who is local, someone that you would trust, of course, would be able to step in the event that, say, you and your spouse or co-parent were unable, because of accident or illness or something, to take care of your kids. They would be able to step in and do that for you, which would prevent the state from needing to get involved and using a system like foster care or something else to make sure that the kids' needs were met.
Hey, Jen, we have a question.
Absolutely.
Is the spouse the default for all these trusts? Like, I think is the question.
Okay, let me look.
Yeah, I think. And Erin, you're welcome to go off mute if you want to ask it yourself too, if it's not answered.
Got it. I think I understand the question. So the spouse is, well, your child's other parent is the like default guardian for them. And so whether that's your spouse or not, like that's, different situations. But if a child has two parents that are alive, then in most circumstances, that other parent would be the default guardian. For the financial power of attorney and the healthcare directive, it depends. The financial power of attorney for anything that you own jointly, you wouldn't need, as long as the other spouse was available to like manage all of those things. If you have a bank account for yourself that maybe you maintain separate bank accounts, great. But your spouse would not be able to get into the bank account without the financial power of attorney. So that's significant. The healthcare advance directive, the spouse, in most states, the spouse would be the person to make those decisions by default. But there are some other things that you can also talk about in the advance directive that can be really helpful and provide guidance for them, especially around like end of life decisions. So, most folks have probably heard news stories about people who are in a vegetative state, they're being kept alive on machines. And then there's this big court battle about like what to do, right? Some people think that it is best to keep them on the machines. Some people think that it is best to remove them from the machines. And so the healthcare advance directive is a place where you can talk about that and make your wishes known to the people who are making those decisions for you. So still valuable, although the spouse, again, is that default. Also, you can have a list of people, right? So say like you and your spouse are driving somewhere together and you're in the same accident, who is going to be able to make decisions for you. That's when the field sometimes becomes a little bit more open, depending on your family situations and relationships. So important to think through that too. These last two things, the personal property memorandum, that is often something that goes with a will or a trust, and it's something that you can update and change as often as you want. Changing wills and trusts are kind of annoying. So it's helpful that as long as you talk about this document in a will or a trust, you can update it as you like acquire personal property of various kinds. Say, grandma's cookbook, I want to go to, my daughter, my camera collection, I want to go to my other daughter, whatever it is. And then that's something you can change over time and keep updated without needing to use an attorney. And so that's super helpful. Also, I really recommend that people think about writing legacy letters, setting a date on the calendar every year, and updating their binders or just a journal or something with letters to children, to friends, to family, to whoever feels important to write to. That would be then available for them to have in the event that you are no longer here. Those things can be like really, they're beautiful gifts that you can offer to people, but also can help to clarify your wishes and your intentions in the event that there is any conflict. So valuable too. Okay, we're doing great. So I gave you a lot of information and I used a lot of words. And so I really appreciated that question. I hope that there are more. And so I wanted to share some steps that you can take right now, because sometimes just like getting started can help relieve some of this burden, right? Seriously, everyone, like 100% of humans that I have worked with, have had this on the back burner for some amount of time, right? It's almost always people, they come to me and they're just like, oh, I'm so sorry. Like I should have done this 10 years ago. Like they just have, there's like shame. And my first thing is like, no, there is no shame in the game. Like you are doing this now. That's great. And so like don't leave that, leave those feelings and just sort of step in, with the confidence that this is something that you can do to take care of your family. So if you are brand new to this process, I suggest you make some lists. There's a worksheet that Brooke is going to share with folks after this. It is not a fancy worksheet. It's just in Word, although that's by design. So you can just like type in your lists if you want, if you don't want to print. And I give you some like prompts and some like categories of things to list. And so often just like drawing some boundaries around some of these things can be really helpful and start to make what might seem unmanageable a more manageable situation. I also, again, encourage really reflecting on goals and values. That's something that I would hope any attorney would ask you when you would, go in for an initial meeting with them. And so reflecting on that a little bit yourself will give you a really great starting point when you eventually have those conversations. And I really do suggest, Brooke, you mentioned at the beginning, how do you find out about this? Talk to loved ones and friends. First of all, it's not something we talk about very much because like death is hard and we don't like to talk about it. But the more we talk about it, honestly, like the healthier I think our communities are and our friendships are, and maybe our family relationships are. And so people, and again, I do this work, so I may be in a weird position. I feel like people are really open in talking about what at least their experience, right? They might not want to tell you like the details of their plans, but they maybe would be willing to tell you like what their experience was, what they enjoyed, what they appreciated, what they learned, what they didn't expect, other things that can help you feel, more prepared or more confident going into the process. So if you have gotten started on this, but you are stuck, I bet there are some of you out there, people get stuck. And there are a lot of like sticky places, right? Like there's a lot that's hard. So like one possible solution is just like identifying the barrier. Like what's the real problem? Is it that, my attorney sent me 200 pages of legal documents that I'm supposed to look at and that's like intimidating? Because if so, like maybe like once you've identified that, maybe you need to reach back out and say like, oh yeah, we need to have this needs to happen differently, right? Like we need a walk through conversation. I'm not just going to read this on my own and pretend that I understand it because that's not likely. If it really is just that it seems unpleasant, right? Maybe schedule a date night, right? Like make a themed drink and like eat some popcorn and go through this with your partner. And feel really great about getting it done and do something fun, kind of in the process, kind of, wrap it around. Maybe you're at a point where you need to think about involving another professional, right? Maybe you and your co-parent can't decide who you want guardians to be. You cannot agree. It is causing a lot of conflict and it's really hard to think about, and you would rather just like leave the process. Consider involving another professional, right? Maybe that's a therapist or a religious leader or a coach, someone else who can get involved and help with that. In theory, an attorney would also be able to help with that. But some attorneys in this space are very, decision focused. And so they are less excited about getting into the nitty gritty about why these choices can be hard. And so depending on who you're working with, your attorney may be able to help you through that, or it might feel better to bring in someone else who has different training. So let's see, is that all my things? You can do it. You can. I work with people every day who feel great that they are going through this process. And so if it feels overwhelming or if you haven't started yet, take a look at this worksheet and get yourself organized. And hopefully that will be helpful. I'm happy to share referrals depending on if you're ready to talk to a lawyer in your state or in your area. I have a network part of a organization of folks around the country, and would be happy to poke around a little bit for you if friends and family don't have suggestions. And as I mentioned, I'm always happy to help with doing a little coaching if you are stuck or anxious about the process and want a little more support before you get going.
Thanks,
That's
Jen.
what I had to share.
That's
What do
awesome.
you have?
I think that's a really great start, because I'm sure it goes real deep of like what all the different options. Sounds like there technically is a 200-page document that, you really are there are lots of there's a lot more. But what does it look like when you go meet with a lawyer? Like, do you have to go in with all of your stuff ahead of time? Like, should you have all these questions answered and then go meet with this lawyer and say, okay, we know the answers, help us plug and play?
Right. So every lawyer is going to have their own process. I think most folks, what most people do is they'll do like a short consultation to get a sense of who you are, your family, like the big picture of what you're hoping to do. That way they'll know whether they would be a good fit to work with you. And then oftentimes they send you a worksheet, like a longer, more detailed worksheet, in which they're just asking you to think about all of the aspects, especially of your financial life, and then also to really think through who you would want your decision makers to be in different scenarios. And so that gives you a chance to like put all of this down on paper and notice where the gaps are and notice the ones that feel really hard. And then when you do an actual planning meeting, an attorney would go through that list and sort of use it like a checklist and say, okay, this is how I recommend handling this thing or this thing. And I noticed that like you didn't choose anyone for this role. Let's talk more about that role and think through like the people in your life who might be good fits for it, et cetera, et cetera. So those meetings often take an hour or two. Mine are usually 90 minutes. And then by the end of that, they can go off and do their drafting. And then, you would receive a draft, and then some people, some attorneys really like to walk people through their drafts so they really understand everything. Others will do it if you ask, but it might not just be a default part of their process.
Wow. Very interesting. Thank you. Well, do anyone else have any other questions? Obviously this isn't legal advice, but definitely open to questions.
I have a few questions, but I'm going to start with one. My first question is, if you're still expecting to potentially have more kids or actually acquire property, or you're renting, at what point is, how much work is it to revise documents to add significant things like additional children and property when you're sort of at the beginning of the journey?
Right. That's a good question. Most, if not all, the default, I would say, for documents is that you name children that may exist. That, like, if you have a kid, it would be like, this is my child's name, but everything in here also applies to any other children that I may have or may adopt over the course of my life. And so that is one way that it's sort of built in to be flexible to your family situation. And then oftentimes, again, in like a will, it would say like, my so-and-so property is going to be divided evenly among my children, or divided in sort of this way. And so if you just have more children, as long as the document says that it would apply to future children, then they just get added to the mix. So that is a default thing that's in there that parents can feel good about, hopefully, in terms of like helping cover that base if they don't get to updating right away. The acquiring property, it depends on what type of property, right? So if you're renting and you don't own a home, then maybe you would say, often in a will, it would say something like, all of my property, I want to go to my husband, or my spouse, sorry. All of my property, I want to go to my spouse. Then it doesn't really, you don't have to name your house like specially. And it would just, once you bought the house, you would just have to know that if you bought it yourself, it would go into that like all my property clause, and then would pass that way. And so there is always in wills, there's always kind of like a catch-all at the end to anything you haven't named specifically, goes into what's called the residue of your estate. And then that would pass kind of according to the rules that you set. So they are flexible in that they can accommodate, changes in your family, changes in what you own. I would say that if you're going to, make a purchase like a home, or like a vacation home, or have more kids, these are all trigger points for when I would review it with your lawyer, right? So a lot of attorneys will do reviews either very cheaply or for free. And they would be able to tell you like, okay, like this, you don't really need to change anything right now. Like everything is still kind of accounted for. Or, here's like a little change that I would recommend, to make things smoother in the future. So yes, those are trigger points for review, but often well-drafted documents do accommodate some of those changes on their own.
So it sounds like timing is, I think Ira's question too with the timing was interesting. It's like, should you do it after your first kid? Is there like a right time or like the ideal time?
So again, like that guardianship piece is such a big deal. So like, yes, like doing it after your first kid, yes. But maybe you think you might want to do a trust in the future, but you don't own a home yet. And so oftentimes a home is one of those things that goes into that bucket, right? Goes into that trust once you have it. And so maybe you just want to do a will now, and then, if you're planning to buy a home in the next 5 years, that would be a time that it would make sense to add a trust, right? So getting that guardianship designation done as soon as you have one kid is, I would highly recommend.
Okay, that's really helpful. I'm going to ask a second question. I have a third, but I'm going to let other people ask. My second question is, I know you can't say specifically, but one of the hesitations is maybe cost. What could you give a ballpark sense of how much this process should cost if you hire a lawyer?
So it does depend on the sort of plan that you want to use. So like I'm happy to share my prices, which are pretty ballpark for my area. For two parents who want to create a trust now, that will run $3,900. And then if they just want to do a will that has, like a trust that springs out of it, like by magic, then that's $3,100. And if they just want to do a will that names guardians, that's like $1,500. And then that includes all of those extra pieces that we talked about, like the powers of attorney, the standby guardianship, the healthcare piece, right? All of that sort of would go along in those packages, which I think is pretty common. So it depends on the complexity of what you need. But those are, I think, fairly accurate ballpark numbers based on what I've heard from folks around the country.
Can you write this off somehow?
Well, I mean, like if you own a business, then there's business planning that could go into this. And so you might be able to kind of squeeze some of this into a business write-off maybe. But don't quote me on that. It would depend a lot on on the mechanisms you were using. But if you do own a business, then that's another reason why this planning is really important. Because you don't want your business, if you're intending for it to continue on after you die, you don't want it to be stuck in probate for a really long time, with kind of uncertainty about what's going to happen to it.
Oh, that's helpful to know, like thinking through like your business ownerships too, not just properties or.
Yep. Yeah.
Anyone else have questions? Iris, you can ask your third.
Okay, this will be quick. Does the will or trust have to be registered somewhere after it gets created? Or does it just sort of just live on its own?
It just is alive. So for a will, many counties will offer like a will storage space. So you pay like $15 or something, and then it goes into like the county's fireproof room or something. I don't know. And so that's one way that some people choose to store it. Other folks will, sometimes attorneys offer to store them. Other times people have them themselves and offer to store them. But like, please, if you do that, tell people where it is because so they don't have to like rummage through your whole house looking for it. But they don't need to be registered anywhere. A trust also doesn't need to be registered anywhere, but you will need to go through the process of retitling your property in the name of the trust. So I could tell you a lot about that, but it might be complicated. But for example, like a deed. So if you own a house and you want to put the house into trust, then you have to go through the process of creating a new deed saying that like you don't own your trust, you don't own your house as individuals anymore. You own your house as trustees of this trust, right? As the bucket holders. And so that would be reflected on a deed that would then get filed and recorded with the county where you live. So there are ways that like information about the trust is out there in the world, but you don't have to like send a copy to someone in order for it to be valid.
Thank you.
Sure.
Anyone else have any questions? All right. Well, thank you guys. Thank you for joining. You know, as Jen, really grateful to have you here. Thank you so much for sharing your knowledge and information. I know you're in Maryland, and thank you everyone for joining. Sprinkles Parents, you know, we're about helping parents thrive. If anyone's around tomorrow, we're doing a toy swap at Avenue Terrace Playground. So clean out your toys, come swap them with other families, and we're going to donate back to the community, which is all about War Sprinkles Parents. So thank you guys for joining, and I hope to meet all of you guys and see everyone soon. And thank you again, Jen.
Sure, no problem. That's toy swap sounds fun. I wish I could come from across across the East Coast.
Yeah, just clean it all out. Cool. Thank you guys.